In these straitened economic times, unfortunately, the word you can see up on the screen behind me has become all too common a word here in the UK, and it's probably no exaggeration to say that at water coolers up and down the length and breadth of the land, on most days of the week, there are probably some employees discussing the meaning and indeed the consequences of this word. And in my experience, most people in those situations feel that however unpleasant the thought of redundancy is, they do at least understand it, and that it's all very straightforward and commonsensical, isn't it? Well, maybe it is and maybe it isn't. Let's have a little look. First of all, let's just remind ourselves what redundancy is. And there are, in fact, legally speaking, 3 different scenarios that would be considered to be redundancy. There's the closure of an entire business. And don't forget, this need not necessarily mean insolvency. It might just be a business closing a division or moving out of a particular sector and deciding to trade doing something else. There's closure of a whole site, workplace closure. The operation's carrying on elsewhere, but you're moving out of these particular premises. That might lead to redundancy. And of course, far and away the most common type of redundancy is the 3rd scenario up on the screen, a diminishing requirement for employees to carry out work of a particular kind. Now, I'd just like to draw your attention first of all to the word employee. Redundancy only applies to employees. It doesn't apply to consultants or contractors or to agents. And it, for example, would have the consequence that if you decided to replace your workforce with individual contractors, well, firstly, you're perfectly entitled to do that. And secondly, if you did it, that would be a redundancy situation. The second little phrase I want to draw out here is work of a particular kind. What on earth does that mean? Well, what it doesn't mean is simply a different way of carrying out the same work. So, for example, if you move from having your workforce carry out its duties during the daytime to organising night working rotas, that's not a redundancy situation. It's the same work, it's simply being carried out in a different way. Similarly, and a question I'm quite often asked, if you want to move from having part-time workforce to insisting that everybody is full-time, whatever that is, it can't be redundancy because the work's the same. And in fact, if you're going from part-time to full-time, for sure, there can't be a diminishing requirement for employees to carry out that work. I want to say a little bit briefly about the words redundancy and dismissal, because in common parlance, the view is that it's never pleasant to lose one's job under any circumstances, but if the reason's redundancy, at least that's kind of a neutral reason to be out of work, whilst dismissal is just bad. And a voluntary redundancy surely is better than compulsory redundancy. Well, in legal terms, a redundancy is a dismissal. Absolutely the same. Why does that matter? Well, of course, if you've got a dismissal, then you're open to possible claims for unfair dismissal. And as Lloyd has already pointed out today, that could, in the wrong circumstances, with the perfect storm, lead to a compensatory award of anything up to £74,200. Goodness me. It's worth spending a little time to get it right. So how do we get it right? What are the ingredients needed for a fair redundancy? Well, they're first of all essentially these 4 items you can see up on the screen. Identifying the pool of employees who are at risk of redundancy. Consulting individually with them all. Having objective criteria you then apply to make your choice. And finally, before any redundancies are concluded, considering whether there's any suitable alternative employment. And I'm now just very briefly going to look at each of those 4 in turn. We're just going to pull out one case to do with each and just look at a very small aspect of it and hopefully give you some flavour of the subtlety and complexity that there is in redundancy law. And perhaps that's not too surprising because redundancy is such a common happening. There's a wealth of case law over the years that's led to that subtlety. Let's just have a look at some of that. I've called this first case, Capita, Hartshead and Bayard, the one with the scheming actuaries, and you'll see why in a moment. Capita were an actuarial firm, and they ran an office in Holborn in which 4 actuaries worked. The reason I call them scheming is that quite a lot of their work, apparently, came from a kind of cab rank scheme system of new business coming in. There was a serious drop-off in this work. They couldn't sustain 4 employees anymore. They only wanted 3. However, instead of, as you might think, identifying a pool of 4 employees and seeking to select which one would be let go, they identified a pool of 1 employee. Carried out the full process of consultation, etc., the employee was let go, and would you believe it, it just happened to be the employee they wanted to get rid of most. Unfortunately, they didn't get away with it. Now, let me just stress that most of the time, employment tribunals will cut employers a lot of slack when choosing the pool. It's generally considered to be a commercial decision, not a legal one. But what this case indicates is you can push that too far. And if you're going to have a pool of 1, and you can, you want to make sure you've got a very clear idea as to why, and in particular to have identified that individual and that role as being work of a particular kind that's different from what others in the same office are perhaps doing. This is the one with the nightclub credit controller, Elcui and Coney Island, which has given me hours of harmless entertainment trying to figure out, first of all, why Mr. Elcui would want to be suing a famous beach in Brooklyn with an amusement arcade. And secondly, what on earth is a credit controller doing working in a nightclub? Be that as it may, Coney Island were in fact a Scottish leisure organisation who took the business decision to centralise all of their finance and accountancy functions at head office in Edinburgh, thereby obviating the need to have any credit controllers working out in the periphery. And the nightclub in South London that Mr. Elcui worked in certainly was in the periphery. The decision made perfect sense. It was communicated to his local manager. He called Mr. Elcui in to give him the good news, and 5 minutes later he was on his merry way, having been made redundant. I'm sure we can all spot the multiple flaws. The most important one, of course, the tribunal picked on was that in rushing the decision in such a way, even in a circumstance where there was only 1 person on the site doing the role, meant there'd been no consultation at all. There wasn't any possibility of that dismissal being fair. So even in circumstances where it seems obvious who's going to be selected, you still need to go through the whole process and make sure that it's complying with the rules. 2 cases to go. Williams and Compare Maxam, the one with the perverse tribunal. You'll see why in a moment. Compare Maxam was a small family business in the southwest of England. They were an engineering firm. They made air compressors of some sort. And they hit the rocks. Bad times, big time. They needed to make significant reductions in their workforce. And the way they decided they were going to do it was that each head of department would be tasked with the idea of deciding who should stay on board the boat in order to try and keep it afloat. Or, as it was put at the tribunal, which were the employees who were best placed to keep the company viable in the long term. And at the employment tribunal, they got away with it. Now, the dismissals for redundancy that ensued were found to be fair. But the Employment Appeal Tribunal, when there was an appeal, looked at it in a little more detail, and it quickly became apparent that these managers had not actually based their decision on who they'd like to keep and who not on any objective basis at all. They hadn't looked at any previous appraisals, they hadn't considered anybody's attendance, sickness or disciplinary record, they hadn't interviewed anyone. It had just, as it were, come from their gut feel about who they thought ought to stay and who didn't. And even though those management decisions were reviewed and endorsed twice, as it turned out, by more senior management, that wasn't enough. The principle is selection criteria need to have some objective basis. For whatever historical reason at the time you're making the redundancies, you don't have any, then you need to create some, and the most obvious and easy way to do that would be to interview all staff at risk of redundancy against particular criteria that you're looking for in order to decide who's most suitable against those criteria. One case to go, here we are. I've chosen Stacey and Babcock Power, which I've called the one with the charge hand rigor. First of all, so we can all get nostalgic about the days when the UK really was a worldwide economic manufacturing power. And secondly, about the days when there really were things called charge hand riggers. This was, to all intents and purposes, an impeccably run redundancy process. Mr. Stacey, along with others, was fairly selected for redundancy, and right up to the date when he was given his redundancy notice, Babcock Power took special care to make sure they checked out whether there was any suitable alternative employment for any of them. There wasn't. Therefore, redundancy notices were served. However, during the 3 months during which Mr. Stacey then worked his notice, other vacancies cropped up. But Babcock Power didn't consider them. They didn't look at Mr. Stacey or his colleagues as being in any way possibilities for the roles, and the original redundancy decisions stood. I'm afraid that wasn't fair. It transpires that the duty to consider suitable alternative employment is an ongoing duty. It lasts right the way through until the very last day the employee is still employed with the employer. Now, whether you want to draw the lesson from that we need to be on our toes and all the way through the notice period looking very carefully as to whether anything else has cropped up, or alternatively whether it's better always to let people go immediately and pay them in lieu of notice so the issue can't arise in the first place, that's kind of up to us. But a salutary lesson there learnt from Babcock Power. So in conclusion, there's a lot more than meets the eye in the law of redundancy. It does carry significant risk with it, and we would say this, wouldn't we? But a little bit of expert advice at an early stage can save you an awful lot of time and money further down the track. Thank you very much.